You shall be heard. God bless the great state of Ohio and this honorable court. You may be seated. Good morning. Good morning.
This is the second day of June 2023. If you have fines and costs that you haven't paid, you can work those off with Josh Cooper on our community service program. After your case, if you tell me you're going to pay today something, you need to pay it. If you don't pay, who's that? What's his first name? If you don't pay, it could be contempt or a bench warrant. So if you're going to pay, pay. And if I give you a new hearing date, you need to write it down. It's up to you to remember to come back here. If you don't come back here, a bench warrant will be issued for you and you'll end up in the Lawrence County Jail, which is not where you want to be. So, if you have a new hearing, show up. If we call your name, you don't show up, a bench warrant's issued, you go to jail. So, always show up. Get you a Post-it note, put it right on your refrigerator door. Let's see here. Okay, we're going to do reviews first.
As I call your name, please come up to the table to your right. Clarence Falk, Charles Martin, Hobart Gearhart.
Clarence Falk, where are you?
Right here.
State your name, sir.
Clarence George Falk, Jr.
Thank you. You have 36 hours community service and $656. So tell me what you're going to do to get those things taken care of.
Well, I've been doing community service here with Josh. I think I've done 24 hours so far, and I have not paid anything on my fine as of yet.
Okay. So, Josh, what do you have to report?
He has been doing this community service, Your Honor.
And is that up to date on my...
Yes.
So, we're going to set it for another review on July 3rd, 2023 at 9 o'clock. And you're going to continue with your community service, right?
Yes, sir.
And what about paying your fines?
I'll be honest with you, money is a little tight, but I will do my best to start paying on that.
Okay. Josh gave you a good report, and Josh will also tell you that you can work off your fines. Tell us how that works.
After you get the mandatory community service done, you can keep doing community service and you'll get $50 for every 6-hour day. $50 credit towards your fines for every 6-hour day.
Well, I will be definitely taking advantage of that also.
All right, thank you.
Yes, sir. You have a good day.
July 3rd, 2023 at 9 a.m.
Yes, sir. Got it wrote down.
Thank you.
Thank you.
Who are you here with today?
Charles Martin.
Where is Charles?
Charles is not at the hearing today. He had an activity that they left for earlier than I got there to get him for court, but he's doing well in treatment.
Okay, now, what did you say before that? Why he wasn't here?
They had a sober activity planned and they left before I got him for court. I think he had forgot that he had court today.
Oh, okay. So he's...
He resides with Bethesda.
And state your name, please.
Taylor Jones Duran. Duran, D-U-R-E-N.
How long is his commitment?
He has completed 6 months of residential, and he'll be doing a year in sober living. He's also monitored through Common Pleas.
Okay. Would another review in 30 days, would that be sufficient, do you think?
Absolutely.
Okay. Who are you with, sir?
I'm with Mended Reeds.
Excuse me?
Mended Reeds,
And what client?
over here.
Okay. All right. July 3rd, 2023, at 9 o'clock for Charles Martin. All right?
Thank you, Your Honor.
Thank you. State your name, Mr. Gerhardt.
Howard Gearhart.
All right. Reviewing your files today,
I got $200 payment.
you're going to make a $200 payment?
Already made it online. Here's a confirmation number.
Okay, hold on.
I have a confirmation number right here.
Okay. What's the confirmation number?
163-141-029 on the TRC 2202479A is in Apple.
Okay,
$200.
all right. Do you still have the animals?
No, sir.
So all the animals are gone?
Gone.
And state your name again, sir.
Oh, I'm sorry.
My name is Brandon Peters with Mended Reeds.
Okay. Do you have a report for me?
Your Honor, I apologize, I do not have a paper report. However, Mr. Gearhart is compliant with our program. He's been meeting with his therapist and AOD counselor as, you know, his treatment plan is required of him. His most recent screen was on 5/25. He was negative for all substances.
Okay, well. I'm going to ask Ron to remember, I wrote some notes on July 3rd, Judge Capper telling him about the animals are gone and that Mended Reeds were here.
Judge Capper knows. They already know.
Yeah.
He knows they're gone.
Yeah, I know he does. Ron and I talked about the case before you came in, and Ron told me that Judge Capper is very conversant with your case. In other words, he knows everything about what's going on. But I want to make sure that all the animals are gone, so you're not having any animal problems anymore.
Just a dog. I got a dog won't stay home,
Uh-oh.
but she's all right. She's all right. She ain't bothering nothing. She just likes to run in the woods.
What is it?
She just likes to run in the woods.
No one's complaining about it?
No, she ain't bothering nothing. She just likes to run in the woods.
July 3rd, Hobart, okay? Write that down.
I got it, sir.
Thank you.
Thank you. Thank you.
Thank you. Hold on just a minute, okay? doing the amendments now.
Yes.
Going to do arraignments now. All right, I wanted to tell you about our 5 arraignments are all OVI cases.
Your Honor, we have room 5. We have some other failure to appear and all that stuff.
Okay. I'll take that back. We have 5 OVIs, we'll do those first, okay? And everybody saw Judge Capper's video, and I'm going to go over the rights again real quickly. You have a right to get a lawyer and a reasonable continuance to employ a lawyer. If you can't afford a lawyer, one will be appointed for you. You have a right to bail. You don't need to make any statement, and any statement you do make may be used against you. State must prove their case beyond a reasonable doubt. And on the OVI cases, I'll go over all of the possible consequences now, so I don't do that for everyone. On your first offense, OVI, it's mandatory 3 days in jail or the school, up to 6 months in jail, $375 to $1,075 in fines, treatment optional, license suspension 6 months to 3 years, driving privileges after 15 days, restricted plates optional, immobilization, no immobilization. So, the consequences of OVI are very harsh. The way the law is written is to try to keep people from driving while intoxicated. I'm going to recommend that you get a lawyer if you can afford one, and if you can't afford one, tell me that and we'll appoint one to represent you, to make sure all of your rights are protected. So, call the first case.
State of Ohio versus Elson Childers, case number TRC 23-629, A, B, and C.
State your name, please.
Elson Caden Childers.
Did you receive a copy of the ticket?
Yes, sir.
The charge is on May 27, 2023 at 37 minutes after midnight in South Point, Lawrence County, Ohio, operating a vehicle under the influence of alcohol and/or drugs of abuse, 4511.19A1A of the Ohio Revised Code, and turn signal violations, 451139. Do you understand the charges and the rights given you on the DVD that Josh showed this morning and what I told you, and the maximum penalties
Yes, sir.
to the charge of OVI, guilty, not guilty, or no contest?
Not guilty.
And I'll enter a turn signal as not guilty, a plea of not guilty. Now, are you employed?
Yes, sir.
You are? Where do you work?
Dairy Queen in Proctorville.
How long have you worked there?
I started probably 2 weeks ago.
2 weeks ago? So did you have a job before that?
For maybe a week at AutoZone.
Okay. How much do you make at Dairy Queen?
10 an hour, I think.
How much did you make on your last paycheck?
The last paycheck, I never got my paycheck because I didn't have my bank information in. So I don't get paid till the 15th.
Okay. I'm gonna find it, from what I've heard so far, you've only been working 2 weeks, you've never got a paycheck, that you are entitled to counsel. Now, let's start off with Luke. This is Attorney Luke Steyer. He's being appointed to represent you on the OVI and the turn signal violations. And Mr. Steyer, Elson has just gotten a job, but he's never gotten a paycheck. So
Okay.
I'm going to find that he's qualifies. So let's start off with bond. Are you under a bond right now?
Did you post any money?
No.
We'd ask for an OR bond, Your Honor.
$10,000 OR bond because you
Sign
did
it
show
right
up here today. Now, it's a urine test,
Okay.
pre-trial.
The judge usually sets those out about 6 or 8 weeks to give the screening time to get in.
Okay,
So
6 to 8 weeks.
looking at that, are Fridays or Mondays gonna be better for you to work, you know?
Doesn't matter.
Okay. We could do the 7th of July. It's about 6 weeks out. Now 5 weeks out, but
Pre-trial set for July 7th, 2023 at 10 a.m.
what's your name, sir?
Elson Childers.
Luke Steyer, $10,000 OR bond.
All right.
Thank you.
Just write that down, July 7th, 10 a.m.
July 7th, 2023 at 10 o'clock.
State of Ohio versus Jarrett Romans, case number TRC 23648, A and B.
In a couple minutes. Yeah.
State your name, please.
Jarrett Wayne Romans.
Did you receive a copy of the ticket?
Yes, Your Honor.
The charge on May 27, 2023 at 48 minutes after midnight in South Point Village, 47 and a 35, 451121C, OVI, operating a vehicle under the influence of alcohol or drug of abuse, 451119A1A, 451119A1D. You understand the charges and the rights I gave you today?
Yes.
You understand the maximum penalties that I went over?
Yes.
On the OVI, guilty, not guilty, or no contest?
Not guilty.
And on the speed, I'll enter a not guilty for you. Are you employed?
I was up until that night. I was terminated for my DUI.
Okay,
I was terminated
Where
for
did
my
you work?
Walmart.
so are you employed now?
Nope.
So they fired you for a OVI?
Yep.
Okay. Attorney Scott.
How are you?
Good. Take care of you.
Thank you.
Any prayers?
No, nothing.
First over the other. Okay.
Attorney Scott, what's your first name?
Jesse,
Jesse?
that's me.
Jessie?
Just an E.
Okay. This Attorney Jesse Scott is appointed to represent you. This is an OVI. Mr. Romans is unemployed. He's got 2 charges, OVI and speed. And he did appear here voluntarily. Are you under a bond?
No.
Set the bond at $10,000 OR. And it's a BAC test. So when do you want the pretrial?
About July 7th, Your Honor.
That'll work. July 7th, 2023 at 10 a.m. Jesse Scott is appointed to represent the defendant. $10,000 OR, plea of not guilty on both charges, set for pretrial July 7th, 2023 at 10 a.m.
Okay.
Thank you, Your Honor.
Thank you.
State of Ohio versus Jennifer Brown, case number TRC 23-649, A and B.
Thank you. State your name, please.
Jennifer Brown.
Did you receive a copy of your ticket?
Yes.
The charges, 2 charges on May 27, 2023 at 4 o'clock. At 4 o'clock in Perry Township, Lawrence County, Ohio. Operated vehicle under the influence of alcohol or drug abuse, 4511.19A1A. And driving outside marked lanes, 451133. You understand the charges and the rights given you earlier today and the rights that I gave you
Yes.
to the charge of OVI, guilty, not guilty, or no contest.
Not guilty.
And on the marked lanes, we'll enter a not guilty plea for you there. You understand the maximum penalties that I went over?
Yes.
Do you want a lawyer to represent you?
Yes.
Are you employed?
Yes.
Where do you work?
Southern Hope Recovery Center.
Okay, where?
Southern Hope.
Okay. What do you do there?
I'm a case manager.
And how much do you make there?
I make like about $450 a week.
$450 a week. Do you have any children?
Yes.
How many?
1.
Okay, you make too much to get an appointed counsel, so you'll need to hire one. How long, I'll set it for a pretrial, how long do you need to get a lawyer?
Probably at least a month or so.
Are you under a bond? Did you sign a bond with anyone?
No.
$10,000 OR bond. Pre-trial set for July 3rd. Write that down, Jennifer. 2023 at 10 a.m.
What date was it?
July 3rd, 2023 at 10 a.m. And as soon as you get a lawyer, call the court and tell them who your lawyer is. And be sure and be here at the next hearing.
Okay.
State of Ohio versus Haley Aaron Johnson, case number TRC 23656 A and B. Haley Aaron Johnson. Did not check in.
Failure to appear, habeas.
State of Ohio versus Justice or Justice Johnson, case number TRC 23657 A and B. Justice Johnson.
Anyone named Johnson?
Did not check in. Did not check
Is
in.
West telling you that? Failure to appear, habeas. Now, Ron is going to call some more arraignments that are not OBIs.
State of Ohio versus Mamie Mullins, case number CRV 181214.
State your name, please.
Mamie Mullins.
You were supposed to be here on May 23rd, 2023. Why weren't you here?
I was at work. We had 4 people quit. I work at Frazier's Personal Care Home in Russell. We work 12-hour shifts. I got stuck on a 16-hour because someone quit. And I tried calling and telling him what was going on. And I've called over and over and over again. I couldn't get an answer.
Who did you call?
John Major, my probation officer.
Yeah, when did you call John?
Multiple times. I've left it on his voicemail. I've given him my number. I actually worked from 7 p.m. to 7 a.m. this morning. As soon as I got off, I came here and waited in the parking lot. Then I found out that he wasn't here, so.
Well, Josh is filling in for him today.
Yeah.
Who do you have there with you?
This is my daughter Karina. She's my youngest of 4. So,
She's beautiful.
thank you.
How old is she?
She is 7 months old. I have 4 that are 5 and under.
Okay. Recall the bench for it, all right?
Thank you. I had her out in the car, but she was cutting a fit, so.
She was what?
She was cutting a fit.
Oh,
She just learned the word mom, and that's all she screams.
so you have a full-time job and how many children?
4.
And you owe $396.
I thought it was $246. I could be wrong. Maybe $246 is what I can work off in community service.
That's probably what it is.
Okay.
Well, my only advice to you is get this done and
Yeah.
get off the probation.
It's a long time.
Look, you have a 7-month-old baby,
Yeah.
and
That's been a part of the time of, part of the reason why, since this happened in 2018, I know it's my fault, but I've been pregnant 3 times, and 2 of them were high risk, her and her brother, and I couldn't work or anything, so I didn't have a way to pay.
where do you live?
In Ashland, Kentucky.
she doesn't have any community service to do, but you can work it off of community service. Do you have any place in Ashland she could work?
Would CARES qualify?
I would have to check, Your Honor. Any nonprofit, we'll accept just about any nonprofit.
All right, 7/3/23, write that down. Somebody write that down for her. July 3rd, 2023, at 9 a.m. You want to put this behind you because
It's a long time overdue. I'm ready to get it behind me now that I just got my own place and stuff, so I got into income-based living, so it shouldn't be an issue to start making payments. And then,
July 3rd, 2023, at 9 a.m. So who takes care of your other children?
well, me and my fiance's, I should say, we switch shifts and we only have one car. So if I work 7 p. to 7 a.m., he works 7 a.m. to 7 p.m. So that puts transportation pretty tight.
What's the name of the place where you work?
Fraser's Personal Care Home.
And Josh will do anything he can to help you. He'll get, if you, let's see, I can never remember the math problem. If you work, how much do you get for working 6 hours? $50?
$50 for 600 days.
And look, you're not that far away, and your case was 2018.
18, yeah.
So as soon as you get this done, you're going to be released from probation.
Okay.
And tell John, by the way, he's not here today, he had something,
So will this be my check-in with him, or will I have another court date?
Josh?
You're, just come in on that day.
Okay.
You'll be
And tell him I said, when you got this paid, to release you, okay?
Okay.
Thank you.
Thank you.
Good luck.
State of Ohio versus Morgan Workman, case number TRC 21125, A, B, and C.
State your name, please.
Morgan Workman.
And you were supposed to be here on October 4th, 2021. Why weren't you here at that hearing?
I'm on the road of recovery, and I just got sober about 6 months ago, and I'm just trying to get my life in order.
Okay. So what's the answer to my question? Why weren't you here?
I was just making bad choices and didn't show up.
Okay. And then, how did you end up here today?
I found out that I had a warrant for my arrest, so I called here and we found out that I had to pay all fines and come before you.
So you're making good choices now, right?
Yes, sir.
And that was a good choice.
Yes, sir.
Okay. Josh, she owes 30 hours community service, and that's it. She's been through Valley Health's program, and you completed it successfully, right?
Yes, sir.
So-
I still see my therapist today. My program's finished with my medication, but I still see him.
Okay. Are you working now?
Yes, sir.
Where do you work?
Salon 30 West.
What do you do there?
I'm a hairstylist. I'm a hairstylist.
Oh. So you got a good job,
Thank you.
right?
Yes, sir.
All right. What are we going to do about getting 30 hours community service.
What,
We're here Monday through Saturday, be here by 7:30.
okay.
Why don't we do this? Write this down. July 3rd, 2023. Recall the bench warrant, please.
July the what?
Recall the bench warrant. July 3rd,
Thursday.
2023 at 10 a.m. No, wait a minute. 9 a.m. for review. Can you get your community service done within the next month?
Yes, sir.
All right. All right, July 3rd, 2023, 9 a.m. for a review. And it looks to me like you're doing everything right now.
Thank you.
Keep it up.
Yes, sir.
Josh is going to monitor that community service and tell Judge Capper what happened at this hearing, okay, and how good she's doing.
Is community service all she owes?
That's it.
If she finishes her community service, she don't even need to come to that hearing then?
Well, I looked at the, you know what, the report is, I think she's still going to be under Valley Health, so let's be here on July 7th. I mean, forget what I said, July 3rd,
Yes, sir.
right? 2023 at 9 a.m. Thank you.
Thank you.
State of Ohio versus Jeanette Boyd, case number TRD 202482, A, B, and C.
Where was the bench warrant? No, I know, where, okay, May 30th?
For Jeanette.
Yeah. Well, you're here for failure to appear at,
I think she showed before she had one issued, because the last one that was recalled was on 12/27/21, so she must have been in the pile to have one.
They used to say, if you don't report within 7 days.
Yes, so we don't have to worry about recalling.
all right. So this is a review. Is anyone here from Mended Reeds?
There was. Ask Wes if he's anybody outside.
Are you still attending Mended Reeds?
Yes, sir.
Wes? Is the gentleman from Mended Reeds still here?
My apologies, Your Honor.
Okay, state your name, please.
Brandon Peters with Mended Reeds.
What do you have to say about Jeanette?
Your Honor, overall, as the report from Tuesday reflected, I spoke with her counselor and her case manager in the days since then. She is still compliant with all treatment requirements. She has been making all appointments and has had negative drug screens.
Okay, Jeanette, state your name, please.
Jeanette Boyd?
Are you working now?
Yes.
Where do you work?
Speedway?
And you owe $620, and you made a payment in April, and you can work off community service 6 hours for $50.
So a day basically for, okay.
So are you going to do that?
Yeah, I'm probably gonna have to do that. I mean, I'm gonna be able to pay some of it too, but I'm gonna have to do both of it. I am, right now, in common police court in Ironton, I had in treatment of blue,
and I'm at the end of my year with it, and I'm having to pay, I just had to pay all my probation supervision fees off this past week, and I still owe $178 in court costs, I think, that I have to get paid off before they release me off of. But it was just, I only had a year to get it finished, and the year's up, I have to.
Okay. When's the year up?
It was up May 4th.
All right. Set it for July 3rd, 2023. Write that down. At 9 a.m. for review. Continue with amended reads. And I'm going to put down you'll work on community service to pay fines.
Okay. Thank you, Your Honor.
Thank you.
We're ready to start some pre-trials right now.
Assistant Prosecuting Attorney Philip Hill is here for the pre-trials.
State of Ohio versus John F. Wright, case number CRB 2311 or 113. Your Honor, it's my understanding that Mr. Wright is currently incarcerated and that Mr. Smith is tied up at the trial. At this point, he's asked for a continuance.
Yes, sir. I'm going to fill in for Roger right now. He's in trial in Judge Bowers' court, and I believe Mr. Wright is incarcerated in Kentucky.
That's what we've been told, anyway. It's a shock. That went out all over the world. Me being sarcastic. The world's going to know me as someone who's sarcastic. I know. I have a reputation as being sarcastic.
How long is Mr. Wright going to be in jail?
I just found out he was in jail. Mr. Smith had asked to continue it a week when he'll be here, but it may be a moot point at this time since he's incarcerated.
Let's set it for I'd rather set it for June 26th. How's that?
That's fine, Your Honor.
All right. Would you notify Roger Smith of that?
Yes, I will.
Thank you.
You know him?
I know.
June 26th, 2023 at 10 a.m.
That's right, he's your dad. Forgot.
State of Ohio versus Casey J. Jackson, case number CRB 22510, TRG 222595 A, B, and C, and CRB 22165 A and B.
Tyler Smith is here on that case. And Wes, I'm calling for Casey Jackson.
Have not checked in, Your Honor.
Thank you.
I guess it was scheduled for 10. It's 3 minutes to 10.
You want to recall this?
Yeah, we'll give him 3 minutes.
Let's just wait the 3 minutes. It'll be more dramatic that way.
We'll recall it.
Ready for a preliminary hearing. State of Ohio versus Allie K. Douglas, case number CRA 23259.
Luke Steyer is here representing the defendant, and the defendant is here.
Your Honor, Ms. Douglas is inpatient at amended reads, because we have a report coming.
Thank you. Hold on just a minute.
Because she's only been there about 3 days at this point.
That's why we don't have very much of a report.
Right. At this time, we also have a case pending in Collin Police Court where she's being followed. For the moment, I think our best bet is to continue this out a couple weeks and a few weeks. I don't know, whatever time the court deems appropriate to let her get some time in so that we get a more meaningful report at a future hearing.
How about July 3rd?
Let me check my calendar, make sure that'll work, but I don't see any reason it wouldn't off the top of my head. That'll work, Your Honor.
Mr. Hill, would you present me with an entry waiving time?
We'll waive time, Your Honor.
I'm one step ahead of you, Your Honor.
Thank you. 7/3/23 at 10 a.m. for preliminary hearing.
Thank you.
And Brandon is here from Mended Reeds, right?
That is correct, Your Honor. And for the, put on the record, Your Honor, I spoke with her housing staff. So far, she is adjusting very well to our program. She's compliant with all current treatment recommendations and has been adjusting well to life in the house.
Great, congratulations. Keep it up.
Thank you, Your Honor.
Thank you. 7/3/23 at 10 o'clock. Got an entry right here, waiving time. Thank you. That was,
Yeah, two
next.
State of Ohio versus Joseph Atkins, case number CRA 23-260, CRD 23-261, TRD 18-2412. Did not check in.
Wes? Did Wes tell you that?
Yes, Wes told me that.
Okay.
Has not checked in, Your Honor.
Well, looks like Roger and I are having a bad day at the plate. We're 0 for 3.
Now, this is Roger's case, right?
Yes. I think he was put on for, he didn't show up maybe last week and on the 26th of May. And I believe that Roger wasn't here and they set it for today, but obviously Roger's in trial in Judge Bowers' courtroom. So I was going to talk to Mr. Atkins on behalf of Roger, but since he's not here, I can't be.
He does have a bond up, Mr. Sowers.
So set it for a bond forfeiture.
Yes.
You can notify Mr. Sowers that he's here and set it for a bond.
And bond forfeiture. Tyler, also, when you're talking to Roger, ask him if Mr. Atkins ever got his driver's license straightened out.
Okay.
So,
Should.
Let's put him on June or July the 10th for that. Yeah.
I'd rather do it July 3rd.
Okay.
Bond forfeiture, July 3rd, 2023 at 10 a.m.
All right.
Thank you.
Your Honor, I'll
That was Josh
Yeah, I'd like to.
Cooper. Thank you.
I still have my recall I have to do.
It's 10:02.
It's 10:02, we can recall that one case of Jackson.
State of Ohio versus Casey Jackson, or recall, CRB 22-510, TRD 22-2595 A, B, and C, and CRB 22-165 A and B. Still not here, Your Honor.
Okay. It's now 3 minutes after 10, and Wes has not informed me that Casey Jackson has appeared. Okay.
There you are, you got five.
Are you going to write that down, failure to
I don't have
appear?
the file. I have, it may be.
Failure to appear, bench warrant. This is Tyler Smith's case.
I'd ask to have 7 days before bench warrant
Bench
issues.
warrant in 7 days.
That way I can try to get him in, hopefully, next week.
Failure to appear, bench warrant in 7 days. I think he's already got a warrant for him out there. See, tell me if Casey Jackson has a bench warrant.
It was recalled on 5/23.
Okay, so he doesn't.
Thank you, Your Honor.
That will give him one.
Thank you. Bench warrant in 7 days. That was Kate, that was Casey. Where is he? There it is.
State of Ohio versus Leah DeChambeau, case number CRB 23326.
State your name.
Leah DeChambeau. Yes, sir. Thank you.
Leah. Ron did fairly well on your name.
You did.
It's DeChambeau.
I'm an old country boy, so it's off to me, but.
And seconded by Josh. All right. States that Leah DeChambeau at Rome Township, Lawrence County, Ohio, on May 12, 2023, while not being lawfully engaged in hunting and accompanied by the owner, keeper, harborer, or handler of the dog, being the owner or keeper or harborer of a dangerous dog or vicious dog, it failed to keep the dog physically confined or restrained upon the premises of the owner, keeper, or harborer of the dog by leash, tether, adequate fence, supervision, or secure enclosure to prevent escape. The said Leah DeChambeau, having been convicted of a prior failure to confine offense in violation of section 955.22 of the Ohio Revised Code, failure to confine M4. Lawrence County, Ohio, 955.22. Do you understand the charges and the rights given to you earlier today?
Yes, sir.
Possible consequences are 60 days in jail, $500 fine. To the charge of failure to confine, misdemeanor of the, that's the misdemeanor of the 4th degree, which is 30 days, $250 fine. Guilty, not guilty, or no contest?
I'd like to go ahead and plead guilty.
So you're going to enter a guilty plea?
Yes, sir.
We have the assistant prosecuting attorney here in the courtroom.
Your Honor, I see here that Ms. DeChambeau actually wrote a statement admitting that her dog got loose again. And it was just recently. In fact, she's probably on probation at this point. There's also, it looked like, something to indicate that maybe she intended to get rid of the dog. So I don't know if that's been done.
The dog warden came to my house initially, and then also again, 2 days ago, the 31st. And we talked, and he kind of gave me some guidance. Due to the prior incident, I did get a fence put up. I know they got a fence as well. My son is actually the one that opened the door when he got out, but we both did get fences put up, and there's a clear understanding now that he is to be in the cage or on the leash before the door is even opened in the house. So I'm taking all the necessary steps to prevent that. There were no incidents. He is a puppy. He did get out. But he was retained pretty promptly, and there weren't any other issues or anything like that.
What kind of dog is it?
He's a mix. Everybody wants to hear. He has some type of pit bull in him. I think maybe boxer too or something. I'm not sure. He needed rescued, and somebody had reached out to me and asked if I would, so I did take him. But yeah.
So where did you get it?
It was a friend. She had other dogs too, and she just couldn't take care of them all. And she reached out because I was looking for a dog at the time. And she reached out and offered them, and I was like, sure, because she was going to have to get rid of them if she couldn't find it, because she just couldn't afford. She had other dogs as well, and she couldn't afford all of them. So
How old is he?
The dog warden came in and looked at him because I didn't even know any of that information, and he looked at his teeth and stuff, and he said he thinks he's around 1 to 2, so he's a puppy.
All right, we're doing sentencing now.
Well, Your Honor, our office has had quite a bit of discussion with the dog warden, with the complaining party, and others concerning this situation. And we're not ready to give a recommendation at this point in time. You know, on the one hand, it's a good thing that she's taking steps to keep the dog from getting out. It's another thing if it's still getting out. Understanding that dogs sometimes want to do that, we just can't let them. We would like to delay sentencing, give us an opportunity. I mean, it's been recommended to her, it's my understanding, that she get rid of the dog. I don't think this is, I mean, I don't know what kind of a dog it is, but apparently the other people in the neighborhood don't trust the dog to not harm them. So it's kind of a situation that needs to be resolved this time.
So how much time do you need?
Yeah, last incident, there was harm to, what was it?
The same victim.
To the same person and their dog, so this is
So, to a human or a dog?
both.
It's on that screen.
So,
Did you ever pay the restitution?
Yes, sir. I paid all of that whenever I was here that day. And I understand he's saying that the people feel some type of way, which I understand, but I just want to make note, the last time that he was retrieved, he was sitting at another neighbor's house, and the lady was sitting there petting him and loving on him. And even the dog warden said he's not vicious. He's looked at his mouth and came and played with them. So I understand, you know, they might feel some, you know, anxiousness. I understand that due to the situation, but like I said, I mean, we are taking all the precautions, and nobody else seems to have a problem with them. Like I said, there have been kids and other people that have pet him and everything else in the neighborhood the last time that he was retrieved. So I don't know if it's just more fearful on their side, which I would understand, but I just wanted to kind of put that out there as well.
What's the dog's name?
Ace.
Ace?
Mm-hmm.
So apparently we have video of this incident. We have video of this incident, which I haven't seen. But I think that what we would want to do is have the input of the dog warden, the victim, the video, at a sentencing type hearing.
All right, how about July 3rd? July 3rd, 2023, at
We can do 10, but we're gonna do all that.
10 o'clock. Sentencing, July 3rd, 2023, at 10 o'clock. Thank you.
Thank you.
State of Ohio versus Adrian Waldron Bishop, case number CRB 23174, A and B.
sworn in Morford here representing the defendant. Adrian is here. And Chris is here from Recovery Resource. Yes, Your Honor.
I called today, they don't have any beds open still.
What were you able to accomplish?
So, since the last time we was here, Your Honor, Ms. Bishop's insurance has lapsed, and she's in the process of getting her insurance transferred over to West Virginia. She attended her therapy session yesterday. We have decided to go ahead and continue services with her and give her an opportunity to get her insurance transferred to West Virginia.
What about her residential situation?
She has been set up with case management to help on that situation. I spoke with the case manager yesterday myself, and they're going to assist her in getting set up with HUD and rapid rehousing through Harmony House.
We're still waiting on bed at Branches, Your Honor. That's still in the mix.
Okay. Are we ready to do, to take pleas?
I don't think quite yet, Judge.
We asked for a trial.
Excuse me?
We would ask for a trial to be set. Our offer was 30 days in jail suspended to do her treatment and be on probation. If she doesn't want to do that, which we've proposed that in the past, then we will just ask for a trial.
What's the time situation on this one?
Well, the time's been waived consistently, so we don't have a time problem at this point. I don't know exactly when it would run, but there's been a waiver every time. So we have time.
It won't be over your head, suspended, so long as you do what you're supposed to do in probation. No new trouble. And it just stays on the show. Okay, Judge, I think she's going to change her plea.
All right. Adrian, to the charge of menacing misdemeanor of the first degree with regard to Crystal Sykes, guilty, not guilty, or no contest.
Guilty.
With regard to the one with Tori Sherrod, guilty, not guilty, or no contest.
Guilty.
Proceed to sentencing. Mr. Morford.
Judge, we'd ask you to accept what Mr. Hill recommended as a joint recommended sentence and adopt it as the order of the court.
All right, let's have it again, Mr. Hield.
30 days in jail suspended, finish your treatment, 2 years probation, no contact order. We don't take any position on fines. We would ask for court costs. And we don't take any position on anything else as far as community service or anything like that. Primarily, we want her to not have any contact with the people who were the complaining parties in this, and we want her to do well in treatment and not have to go to jail.
Mr. Morford.
That's the same thing we want, Judge. Transportation, I believe, right now is an issue. She's expected to come and report in here for probation. You don't have to.
That's
So
130 days, correct? One, Mr. Hield?
30 days, yes, sir. Yes, Your Honor.
Okay. You have everything? All right, it's 30 days in jail suspended, 2 years probation, continuing treatment, and it's,
Giving her a review date at 9/11/23.
review date 9/11/23, and the fine is $1,000 suspended. And that comes back up like a jail sentence would. In other words, you don't have to pay it, it's suspended unless you don't do what you were supposed to do. And the costs are also suspended under the same terms. And let me tell you why I'd never do that. You're basically homeless. You don't have a way to get anywhere. But you're trying. You're trying to get through this. So I'm not going to put those fines and costs on your back.
Thank you.
Like Mr. Hill just said, what we're mainly interested in is the treatment. So you've got all these people wanting to help you. Take their help and get past this. And I'm not laying anything else on your back. I just want you to succeed. All right?
I understand.
Okay, got all that? Review, Mr. Morford, 9/11,
At 9 a.m.
9 a.m.
Thank you, Your Honor. First when you come back. Notice that's at 9.
Alright, when do I come back from? Where do I go and what do I do for probation?
Thank you, Your Honor.
Thank you.
State of Ohio recalls Joseph Atkins, case number CRA 23-260, CRD 23-261, and TRD 18-2412.
I'm going to mark all that off. And this one is Roger Smith's case. Ronnie Tyler,
Can't be here, Tyler was here on the office, he's still here on Josh's check.
Tyler Smith's here on behalf of Roger Smith, and Joseph Atkins has appeared, and I'm taking off the bond forfeiture hearing, and we're not going to issue the warrant. Now, go ahead and state what you have to say so he can hear you.
Roger's in trial today. That's why I'm his brother. I'm stepping in for him today, but just give me a second. Let me.
Oh, he's got the theft, okay.
Back in OVP on Monday, I got kicked out when I went to jail. I didn't call him. I had a 30-day suspension because I didn't show up because I was incarcerated when I got arrested over here.
Okay. So you go back.
I go back Monday morning.
Where at?
OVP.
Now, it's my understanding that this gentleman is going to OVP. I don't know whether residential OVP?
What is it,
Are you
sir?
going to go to stay there, OVP, residential?
I was in there outpatient because I work and I have kids.
The charges, while they obviously are not proven at this point, are concerning because of the drug possession issue. And so what we would want to do is have this gentleman, Mr. Atkins. Is that
Yes, sir.
Mr. I don't have the file anymore, but we want him to start in treatment. And he says he has plans to go to OVP, and then we'd come back at a later date. And if he's successful in treatment, we would, in all likelihood, agree to keep that felony case here, not take it to the grand jury, and allow him to be successful in treatment in this court, as long as he kept on being successful. As far as the theft charge, we will have to deal with that in one way or the other, but we won't ask him to enter a plea on that today, other than not guilty.
I don't have the felony charge. What is it?
It's a possession of drugs,
I don't have that file.
heroin. It is 23 CRA 260.
Maybe it's somewhere in here. Hold on. I've got a theft. Got a theft.
Should be.
Oh, there it is. Felony 4. All right. So, what are you proposing?
I would propose that Mr. Atkins go ahead and check in with OVP, and that we come back in a couple weeks. At that time, we would expect that he'd be engaged in the treatment there at OVP. We could get a report from them that would tell us what their plan for him is. If he's already talked to them and they've decided that he can do outpatient, I understand if he's got obligations with children and whatnot, that it's a real struggle to try to think about going to residential treatment.
Yeah.
But we would be okay with coming back and taking a look at it here in a couple of weeks to make sure that he's committed to being in treatment, so that we can agree to keep the case here instead of taking it to the common pleas court, if he's willing to do that. Of course, it would require a time limit or two.
Well, let's make it July 3rd. And would your client be willing to waive time?
Yeah, you'll have to.
Yeah.
Yes, Your Honor.
Okay. Joseph, did you ever get your driver's license?
I'm working on it. They were suspended due to child support being behind.
Is that the only reason?
Yes.
Did you get your child support?
It's almost caught up. I've got a court appointment to try to get them to release it to where I can get them back to drive back and forth to work and stuff.
Where is your child support order?
I have child support through over here and in West Virginia. I have a son over here and a daughter in West Virginia.
That would go a long way to help you on July 3rd if you could show up with a driver's license.
Okay, I'll try to have it done by then too.
Where do you work?
I work at the Delta Hotel, downtown Huntington.
Mr. Smith, are you happy with that?
Yes, Your Honor, that's fine. I've discussed it with him. He's willing to do the treatment, and we'll set it for July. We'll keep it July 3rd. I believe that's when the other hearing was set anyway, so I'll let Mr. Smith know.
All right, here's what we have. Pretrial and preliminary on 7/3/23 at 10 o'clock, and pretrial on the driver's license case on the same day. You're going to try to get all that driver's license stuff taken care of?
Yes, sir.
Some bureaus of support will take that off and as long as you're making some payments.
Yeah, I have been. I've been making my payments now for 9.5 months straight. I haven't missed a payment. They directly take it out of my check.
Release that. Is that your experience, Tyler?
They can, yes, I think,
I
senior paying.
was a really far behind on it, is why they haven't released it yet, but I'm gonna trying to get them to.
All right, and we'll see everybody back here on 7/3/23 at 10 o'clock.
All right, I need to write this down too. Is that fine?
Yeah, that's yours.
Thank you, Judge.
Thanks, John.
Thank you.
State of Ohio versus Austin Pritchard, case number CRA 18-1233 A and B, CRB 18-1234 A and B.
Mr. Warren Morford, this is the defendant. I've just been handed a report. And state your name, ma'am.
Michelle Massey.
Michelle Maxey. This looks like a good report. Would you agree with that?
Yes, Your Honor. He's just recently come back into services after being released from STAR, but he's much better this time.
Mr. Morford?
May I have 1 second, Judge? Probation for how long?
Probation for 3 years.
3.
Yeah.
Judge, he ended up at Lawrence County Recovery after release from STAR pursuant to a sentence in Lawrence County Common Pleas Court. It is his intention to finish his program at Lawrence County Recovery and become sober again.
Where you have a clean report, clean test.
Yeah. Yes, sir.
That's a good sign. So what are you recommending today, Mr. Morford?
Maybe continue 30 days, depending on your calendar, Judge, and see how he's doing at Lawrence County Recovery.
2023 at, this would be sentencing, July 3rd, 2023 at 10 o'clock. And continue with counseling. Are you working now?
I'm on a blackout period right now, but as soon as I get done with that, I will be.
Where are you going to work?
Engines Incorporated.
That'd be a good place.
Yeah.
What do you do there?
Huh?
What do you do there?
Weld.
When will you start?
18 days from now.
Great.
I've been there for 3 years. Just had to.
Everybody needs welding.
Yeah. Yeah.
It's a good profession. All right, we'll see you on July 3rd, 2023 at 10 o'clock.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Moore.
Okay, let's take a brief recess, then we'll go do the jail case.
I'll call him. Take victims real quick.
Who's he living with?
Both of them that's here for the commitment.
Oh, okay, yeah, I'll tell Josh. Orange County Municipal Court's now back in session. State of Ohio versus Matthew Gonzalez at the Lawrence County Jail, case number CRB 22377, CRB 22362, CRB 22343, and CRB 22309. Your Honor, this is for review.
There is Matthew.
Okay, it's on the screen.
He's right there.
Oh,
It needs to be enlarged. I don't know how to do it.
can we bring him up to,
Josh, probably, the prisoners up there that Wes, is Josh around somewhere?
He's calling deputy.
He's, okay, we need somebody to get these prisoners up on the screen
Okay.
here.
where did Wes say he was?
Yeah,
We can go ahead and put that on the record. I don't know what's.
Okay, let's do that.
The instructions the same for the back. I've got the ones for the back written down. That would help you. I'm not from that. Okay.
State of Ohio versus Keon Gage, case number CRA 23238. State of Ohio versus Daniel P. Askew. No, sir, you don't need to come in. We're just, you have recorded. State of Ohio versus Daniel Askew, case number CRB 23252.
That's the ones that are
Your Honor, these two were ordered to report here for jail by 11 a.m. today, and they have done so. They have both reported.
Let the record show that Daniel Askew and Keon Gage have both reported, and someone's going to come and get it.
Yes.
They usually they call these here for jail fees, but he said.
And they should have a new review, 1229
Yeah, exactly.
and 95.
What happened?
Oh, I pushed something, because I was going to try and make them bigger so they could see that. That's all it was. I pushed something very big, like that one, but maybe coming off and coming back on. Don't let me touch it. Yeah, we go watch movies.
You didn't change the channel, did you?
Okay, we'll go to connections.
That's all I put the ones
And
that.
go
That's
to,
what I need to do right there.
yeah. There we go, how do we get Matthew? Oh, you just got to click him with the mouse then.
Hello.
There it is.
Okay, there we go.
I got you. I got you. We got you back. It is, that's what it is.
It's just a review,
All
right?
right. All right.
Just a review there.
State your name, Matthew. Matthew, can you hear me?
Yes, Your Honor.
Okay. You're in the Lawrence County Municipal Court by virtue of a video teleconference. Why are you in jail today?
That's what I'd like to know.
He's got charges in common police court.
All right. I've just been informed the reason you're in jail is you have charges in common police court. What, do you know what they are? Mr. Hill?
Yeah, what are the charges? Is there a burglary charge? Domestic burglary, violation of protection order. He had several such charges here in this court for which he was found guilty previously, and then he graduated to felony cases against the same victim.
Okay, I'm going to tell you what Mr. Hill just told me.
He has a hearing in common police court next Wednesday.
You have a hearing in common police court next Wednesday, and you're being charged with burglary and violation of a protection order. Now, you're here for this court for a review, and I'm going to tell you what's going on with that. You owe $1,252 in fines and costs, and you have a no contact order. So those are the main things to stay away from Ashley Wallace. I'm thinking the best thing to do would be set this for another review, Mr. Hill. What do you think?
I think that sounds prudent, Your Honor.
And would you say how long? How about 30 days?
I think that sounds appropriate, Your Honor.
Okay. Review 7/3/23 at 9 a.m. And I said 7/3, July 3rd, 2023 at 9 a.m. for review. Okay, do you have any questions, Mr. Gonzalez?
No, Your Honor.
Okay, we'll see you back here on 7/3/23, and if you are allowed out, you need to be working on your fines and costs and stay away from Ashley Wallace.
I completely understand everything, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Carl Tooley II, or Junior, case number CRA 23325. And William Smith Jr. is on deck.
Well, you look like a criminal to me for some reason. Okay, so it's your son? Yes. Is he in jail?
Yes.
So what's going on there? Has he ever been in treatment before? Well, we'll just offer him the choice of either on treatment or staying in jail. That's,
No, we just want what's best, really.
if he got out to go to a treatment facility, would there be a chance that he might take off?
I'm going to keep going. He knows how bad his problem is. Yeah. It's just like everybody else that thinks they have a problem.
Is he living with you?
Yeah, so he comes in and out. Stay home. Get home. Yeah, to register. It's been going on for a while.
Okay. All right, well, we'll try to help him.
State your name, Mr. Tooley. Okay, I'm going to ask you to speak a little bit louder.
Carl M. Tooley, second.
Thank you. That's perfect. Do you have a copy of the complaint in front of you? Do you have it in your hands?
Yes.
Okay. I'm going to read your complaint. It states that Carl E. Tooley II at Fayette Township, Lawrence County, Ohio, on or about May 31st, 2023, did by threat of force knowingly cause Carl E. Tooley, a family or household member, to believe that the said Carl E. Tooley II would cause imminent physical harm to Carl E. Tooley, a family or household member. The said Carl E. Tooley II, having been convicted of a prior domestic violence offense in violation of 2919-25C3 of the Ohio Revised Code, domestic violence misdemeanor of the second degree in Lawrence County, Ohio. You are in the Lawrence County Municipal Court by virtue of a video teleconference. You have a right to remain silent, and any statement you do make may be used against you. You have a right to an attorney and one appointed for you if you cannot afford it, and a right to a continuance to hire a lawyer. You have a right to bail, a right to a jury trial where the state must prove their case beyond a reasonable doubt. Do you understand the charges and the rights that I just gave you?
Yes.
Okay. The possible consequences of a misdemeanor of the second degree are 90 days in jail, $750 fine. To the charge of domestic violence, misdemeanor of the second degree, I'll ask you to enter a plea of guilty, not guilty, or no contest.
I'm guilty, it don't matter. I'm guilty, fine.
Plea of guilty, proceed to sentencing. Mr. Hill.
Your Honor, I have the benefit of Mr. Tooley's father being here to fill me in on what's going on. And Mr. Carl Tooley II is a 40-year-old man who, comes and goes from his parents' residence. Sounds like he avails himself of their goodwill and their desire to help him, and then he thanks them by being aggressive and threatening violence, and it all relates to drug use. And I don't know that Mr. Tooley is willing to agree or understand that at this point in time, that this behavior, not only is it unacceptable, but his family wants him to get help, but maybe he doesn't want help. So we would like to offer him a couple choices, either 90 days in jail.
Wait a minute.
Maybe there's mental health, maybe it's mental health issues, whatever it is, you don't
Wait
be.
just a minute. Listen to what the prosecutor is saying. I'll give you a chance to talk.
You know, maybe the person stops using for long enough to be able to have a clean drug screen, but I believe his father, I don't think he would be standing here telling me these things if there wasn't some truth to them. So what we're proposing is, yeah, probably drug screen's probably a good place to start, but he needs to be either in jail until he's willing to go to treatment, which would mean a 90-day jail sentence, or agree to be assessed and go to treatment, a residential program with electronic monitoring with GPS. Those would be, or we could return for sentencing, we'd ask for a $10,000 cash or surety bond.
Okay. Now, I want to make sure that you heard everything Mr. Heald is proposing. Did you hear what he said?
Sure, something about rehab, about 90 days in jail, something about sitting here till whatever, I think 90 days, I'm good. You can put me in rehab, you can give me a year straight right now, I wasn't on drugs, every time I walk through that door, they say I'm on drugs. My sister breaks into her room, steals her thing out of her house, he takes her to get heroin if she's sick. I don't do heroin. And you're telling me that I went there to get some clothes and asked if my sister was okay, just like I'm talking to you right now.
Let me ask you a question, Carl. Let me ask you a question. Do you have a job?
No, I don't have a job. Does she have a job? Does he have a job?
Okay, listen, that was a yes or no question.
Yes.
Do you have a job?
No, I got 90 days in jail. I did, I believe it. Yeah, I'll take it. Give the 90 days.
Carl, help me.
No longer. Now I am. I'm telling you, you got me crazy.
Do you have a job, Carl?
Hey, it's like my dad. Do you not listen? No.
Okay. You know what, I'm going to appoint an attorney to help you here. And Warren Morford is sitting here in the courtroom. I'm going to appoint you to represent him. And have you been listening to what's going on, Mr. Morford?
Some of it, Your Honor.
Okay.
Not 100%.
I'm not 100% sure that, I don't want to do what Mr. Hill was
What do you say? I have headphones on.
Sir, just to put some more, but I'm your attorney. I'm going to tell you not to talk right now and let the court speak. And when it comes time to, I will come and call you on the telephone where we can have a confidential, private talk. But right now, you would best be served by being quiet.
Let's have that conversation right now. Let's take a recess. Okay.
Judge, may I have your file?
You may.
All right, so he's going to talk to her on the phone, and then I can see what
Next case.
State of Ohio versus William Smith Jr. Danilo Lynn Hodge is on deck.
They're going to recall the case in a few minutes, so you can have a seat if you want to.
Okay, this is William Smith.
Who do we have up there?
William Smith. State your name, sir. Okay. I'm going to ask you to talk a little bit louder. What's your name? Thank you. Perfect. Thank you. Do you have a copy of the complaint in front of you?
Yes.
Great. I'm going to go over it with you. But first I'm going to tell you about your rights. You're in the Lawrence County Municipal Court by virtue of a video teleconference. You have a right to remain silent, and any statement you do make may be used against you. I was going to ask him to get you.
Yeah, I'm here.
You have a right to remain silent. Any statement you do make may be used against you. You have a right to an attorney and one court appointed for you if you cannot afford it. You have a right to a continuance to hire an attorney, a right to bail, a right to a jury trial where the state must prove their case beyond a reasonable doubt. I asked Josh to get Luke Steyer in here, and Luke had read my mind. And he's standing here in the courtroom. Josh didn't have to get up. Now I'm going to go over the complaint. It says that William Smith at Union Township, Lawrence County, Ohio, on May 31st, 2023, did knowingly obtain, possess, or use a controlled substance or a controlled substance analog, and the said drug involved is heroin or a compound mixture, preparation, or substance containing heroin. An amount of said drug equals or exceeds 1 gram but less than 5 grams, to wit, 1 gram in violation of 292511 AC 6B of the Ohio Revised Code, possession of heroin, felony to the 4th degree. And that was in Lawrence County, Ohio. The possible consequences are 6 to 18 months. No, yeah. $5,000 fine. You understand the charges and the rights that I gave to you? Mr. Smith, did you understand all of the charges and the rights?
Yeah, I understand.
Okay. Are you employed?
No, I'm disabled.
Do you want a lawyer to represent you?
Yes.
Okay. I asked Luke Steyer to come into the courtroom and listen to this arraignment, and he did. And Mr. Steyer, I'm appointing you to represent William E. Smith Jr. on this 4th degree felony. So you have a lawyer now, and he's standing right over there, and he's been here the whole time. Now, let's talk about the issue of bond. I know, Mr. Steyer, you just got this case, but let's see what Mr. Heald has to say.
Your Honor, there is a 3rd degree felony, which increases the severity of this.
I thought it was a 4th degree felony.
Well, there's 2 charges.
Oh, I'm sorry, wait a minute.
We'll waive reading of that, of the additional charge, Your Honor.
Thank you for telling me that, Mr. Heald. We have a felony 4 and a felony 3, and your lawyer has waived the reading of that.
No, it's in my possession. So it does, it causes a great amount of concern. There is the potential that we could elect to take this case on to the grand jury, and we'll make that decision at a later date. But in the meantime, if Mr. Smith thought that he wanted to get started in treatment as opposed to staying in jail, then that might help us to decide, number one, to keep it here. It might help him if he's got drug addiction issues that appears that he probably does based on the charges. It is possible that we could agree to keep the case here and let him go through treatment and actually dispose of the cases here with maybe even dismissing the charges if he's successful in treatment. If he doesn't want to do that, then we're going to ask for a cash or surety bond and we'll take it to the grand jury.
All right. Mr. Steyer, I know you've done many cases like this.
Sir, may I ask?
Please.
Sir, would you be willing to be assessed for drug and alcohol treatment?
Yes.
In that case, then, Your Honor, we have somewhat, you go over there and talk to him?
Yeah.
Okay, we can get somebody down to the jail to speak to him. we would ask for an OR bond in this matter. And if an OR bond is granted, we would be willing to go beyond the 10-day, or beyond the 15-day in the case of an OR bond requirement for the preliminary hearing and set it on a date that's convenient to the court.
We would not be opposed to an OR bond, but we'd like to know that he's going to be in a program before the court would allow the OR bond.
Well, I would ask then for an OR bond with the condition being that he undertake care as recommended by, what agency are you with? I'm sorry.
Bethesda.
With Bethesda.
Is
Do
that
you
for
have
outpatient?
space right now?
Yes, we do have an available bed.
And what is your name?
My name is Derek Berry.
I would leave the question of the level of care up to the result of an assessment by a licensed CDCA. But whatever that is, that he be required to participate in that level of care.
All right, let's assume that he's going to be released into the custody of a care provider. When would you want the hearing?
On the date convenient to the court.
And you're waiving time?
We would, should that bond be granted, we'll waive time.
All right. Would 30 days be enough?
We usually would go back a little closer than that. I'm not here the 20th, 23rd, or 26th of this month, so
You are not?
I'm not available those dates. The 16th is 2 weeks from today. I think that sounds appropriate, if that day is available for the court.
Judge Capper doesn't want anything set until June 20th unless we have to due to time.
Well, we don't have to due to time if he's given that bond, but it will have to be the 30th at the earliest if it's after the 20th.
We would want Bethesda to know that if he leaves or whatever, that it's not cooperating, we need to know so we can get it back into court sooner.
Did you hear that, Mr. Berry?
Yes, sir.
Okay. Now, Dorothy, I want you to, you just got here, didn't you? You didn't hear any of this so far?
I heard it all.
Oh, great.
I've been sitting here.
All right, so here's what, just to go over it. It's a $20,000 OR bond only if he's released to a care provider, which Bethesda, Derek Berry is doing the assessment. If he's not, then we need to get it right back in here within the 10 days.
Yes.
Okay? We're appointing Luke Steyer, $20,000 OR bond only if he's released into the program that Bethesda is going to be providing.
So Bethesda would need to notify the court then of the assessment if they don't. And they would need to notify us if it's inpatient or outpatient.
Well, that's my question. Are you saying that you're only going to give him an OR bond if he assesses for inpatient, or are you saying you'll give him an OR bond and he has to do what they tell him to do?
I want to hear what the state has to say.
And I understand that there's some level of the implication that we want it to be residential, but we're not the professionals to make that determination. But on the other hand, I think there's some sort of maybe reason to presume that with that level of drugs in his possession, that there is probably the need for a higher level of intervention. And I don't know whether I'm right or not. I think that if he's not going to be in a residential program, then there ought to be a bond.
In that case, Your Honor, I would just set, I'm not going to I can't enter a time waiver if I don't have a guarantee of a bond. So I guess we need to set this within 10 days of his coming into custody.
When did he enter custody?
Looks like May 31st. And that's fine too. I would still request that Bethesda go ahead and assess him, and we would be agreeable for him to being released to residential treatment after they've assessed him and determined that he needs to go to residential treatment.
We could also come back on the 2nd, down here next week, we can just come back and find out what, I'm not the 2nd, today's the 2nd. We can come back on the 5th to find out what the assessment was, and if the assessment was for inpatient and the state's agreeable to continuing the case on, we could then, or, I'm sorry, is agreeable to an OR bond at that point.
Okay.
Or even we could let him out to inpatient at that point, and then I could do the time waiver.
How about this? How about we come back on the 5th?
Yeah.
He gets assessed. If they can take him before then, before Monday, then we'll make it an OR bond even today or whenever.
That's fine. That'd be fine.
All right. Do you have all of that, Dorothy?
Well, I'm just trying to decide what to put on the warrant of discharge. Do you still want it to be a $20,000 bond assessment? Release to Bethesda at...
Can be converted to an OR bond if he is released, if he's accepted as a residential patient at Bethesda. Otherwise, we would like for there to be the cash or surety bond.
Okay, then I would just ask that Bethesda notify the court, so we won't send down this warrant to discharge until, because on occasion, the jail has released persons if we send down a waiver to discharge. With all these conditions, they're not looking at it, they're just seeing a waiver to discharge and they release the person. So I don't want to send it down to the jail until we're notified by Bethesda, so they can call either myself or probation.
I'll step out, get on the phone.
I'll go ahead and prepare and just have it in the file.
Okay.
So we'll just set this back for Monday?
Yes.
Thank you.
Luke?
Yeah.
I got a prosthetic leg. Disabled.
He has a prosthetic leg.
Yeah.
Doesn't matter.
We can accommodate that.
That's not a problem, sir.
Thank you. So it's set for preliminary on 6/5/23, and the bond is $20,000 OR if he's released to Bethesda. If not, we're having a hearing on 6/5/23.
Thank you.
Thank you.
State of Ohio versus Danilo Hodge, case number TRD 182433, TRD 151124, CRD 15986.
Yeah.
May it please the court, Your Honor. Ms. Hodge was sentenced on Wednesday to 17 months incarceration. She'll probably, I would assume, be sent on to Department of Corrections probably in the next week or so. It was Judge Capper on our last hearing had suggested that I discussed with the state on that matter, folding these issues into that. They were agreeable to that, so what we expect to do, what does she have left? At this, well, I know there's a stack there.
I got a question when y'all get done.
Okay, 494, add these up.
Okay. Well, hang on, can I just say, Mr. Hill?
Roger's computer shows a
Okay, what's it show?
balance of $1,441.
Yeah, whatever.
Your Honor, the state's agreeable, and we would be agreeable to convert this to a 45-day jail sentence to be run concurrent with her sentence from common pleas. And then that would complete all cases by jail time.
Including community service?
Convert everything to 45 days jail time, concurrent with her common pleas case, and complete the cases by jail time, Your Honor.
One of those cases has restitution though.
I don't think there's any, I wasn't aware of any restitution. I thought we had fines, costs, and community service.
You have to look at each case, I just know.
Is there restitution in cases, Mr. Hill?
Is there restitution on Danita Lee Lodge?
What file?
Yeah, those are all, they've been on review for a long time, so we don't have the file. I guess we could look online.
One's restitution of $18. Walmart.
Well, all case numbers do have, Your Honor, because not all of these are online.
Okay. 15,986 is the $18 Walmart restitution. 18,2433 is
That one.
DUS, so there wouldn't be any restitution on that one. 15,1124, I don't see any restitution on that one. And 13,1814. That is DUS. So the only restitution I see is $18. Is that what you see?
Yes, that's the only thing I saw here. I just wanted to check.
Do you have anything to say about that, Mr. Hield?
I don't have any way of knowing other than looking online, so I guess that's what you've already done. I don't guess.
Your Honor, Walmart has if there's a restitution order, Walmart has the ability, if it wishes to get its $18, to come down here, get a copy of that, convert it to a judgment, and put a lien against property or take other steps to collect.
It's only, normally if it's an individual, that the judge would hold that out, so. I just wanted to check. I knew she had a bunch of cases. I couldn't see them all. I didn't have them all before me, so I wanted to check and make
We're
sure.
going to let Walmart
that
pursue their remedies,
What was the jail time again? Would you recite that again?
which they want.
45 days to cover all cases concurrent with her common pleas sentence.
So does that release her from probation right now?
If that's the order of the court that all cases are completed, are to be completed by jail time, then it would release her from probation once the cases are completed in 45 days.
Okay, now, how do you pronounce your name?
Oh, yeah.
Miss Hodges, Miss Hodges?
It's Danita Lee.
All right, Danita Lee, if you want to speak, you can. But your lawyer just got you the best resolution of your case that you can have. I don't see anything that you would have to say that could make anything better. But you have the right to speak if you want to.
I was going to see if I could get a rehab on them once, but I said it's too late for that probably too. But also, I was going to see if I can get something done where I can please see my kids one last time.
Ms. Hodge, this court doesn't have any power over that. You're being held by the other court, so this court doesn't have any authority on that issue.
The prosecutors have to look at this. It takes everybody. This court's probation department is no longer involved. It's all common pleas, and we're going to sign that entry that Dorothy is preparing.
So
if I go back to court on common pleas,
you don't go back to court on common pleas. You've been sentenced.
I thought I appealed it too.
Well, that's not a common pleas. That'll be I will file a notice of appeal on your behalf. Someone will be appointed to look at that question, and that'll go on to the appeals court.
Okay.
So
I don't get to see my kids or anything before I go there?
I will ask and see if I can do something with common pleas on that, but I can't promise you that that's a possibility. I'll see what I can do.
All right.
So you're clear of all municipal.
But this case is, this court, you're finished.
All right.
State of Ohio versus Carl E. Tooley II on recall, case number CRA 23325. Carl Tooley II on a recall from Lawrence County Jail.
Need Mr. Morford on that one?
When do you go to Florida?
President in court are Mr. Warren N. Morford, and on the video, Carl Tooley II and Philip Hill. Mr. Morford asked for a brief recess to speak to his client, and that's what we did.
And I've also spoken to my client's father, Mr. Tooley, here as well, Judge.
Hey, Your Honor, we'd ask he be found in direct contempt on that. He gave him.
Of course he would.
Well,
I played it off, I'm gonna play the hell off, I played the car off. That's a TV screen.
Easy doesn't feel, really, you're
Hi, Daddy. Hi.
getting ready to lay a torch.
Okay.
Judge,
Hair looks good, Dave, by the way.
my instructions were to accept the offer of Mr. Hill. Personally, I believe the man is in dire need of some mental health treatment.
Oh, boy.
And I'm sure that's not going to sit too well with Mr. Tooley, but it's my considered opinion, Your Honor, that whatever happens here, I would like to see him be evaluated for mental health issues and treated. I don't know his past, Your Honor. I don't know if he's been hospitalized. I don't know if he's seen mental health providers, if he's been on psychotropic meds. There's a lot of things I don't know, but I do know from the brief conversation I had with Mr. Tooley, his mental health gives me a grave concern proceeding forward.
Okay. What are you suggesting as his lawyer? I just appointed you, and I haven't given you much time to get ready. What are you suggesting? I'm asking on behalf of your client.
Mr. Tooley, do you understand the charge you're facing?
I asked you a question, Dave, asked me, I asked you a question, answer your question, and I'll answer yours.
Well, the way this works is I'm asking you the questions right now.
They asked you questions, mental health said, what's your answer to the question? They just asked you what my mental health said, we'll do an evaluation real quick.
See?
Now.
It's very difficult for me to get a direct, responsive answer, Your Honor, to my questions.
See, I asked your lawyer a question, and in order for him to answer that question, he needed to ask you one, and that's fine. Okay, now. How about this, Mr. Tooley? Your lawyer's trying to help you. Answer his question. Ask it again, please.
Do you understand what you're charged with? That being a domestic violence, a misdemeanor of the second degree?
Yeah, I do, yeah.
Okay, and do you also remember our conversation where I told you that each subsequent conviction of domestic violence brings a more severe penalty, and the third one you could be looking at prison?
Yeah, this is the second one.
Okay, and you understand that?
No, yeah.
Okay, and
what's your point?
well, sir, please don't use profanity. That's going to get you held in contempt. This is a court of law.
Oh, no, well, then I'll be going to jail for something, you know.
Your Honor, I have a suggestion. And this is in speaking with Mr., I'm sure it's going to be a dandy, I'll tell you. Mr. Tooley's father, who is here and has grave concern for his son, whether his son realizes it or not, believes that a few days in jail to clear his mind might allow us to have a productive conversation.
We're going to have the same conversation within 3 days, we're going to have right the fuck now, that's how.
So I don't think we can do anything. I don't think we can do anything productive.
I don't think we can either. Man, you want 3 days, you want 3 fucking weeks.
Mr. Tooley, you asked me to find out if your sister was safe. Your father assures me that she is safe.
All right, good. Why don't you go fucking get her out of Huntington?
Let's everybody listen to what Mr. Heald says. I'm going to tell you this. I can't listen to you and another person. So I have to focus on one person, and I'm focusing on you, Mr. Heald.
Well, Your Honor, I mean, he's entered a guilty plea. Okay, so from that perspective, we would be moving on to sentencing. But I believe that in order for Mr. Tooley to be able to, for us to reasonably determine what's best to happen in this situation, the sentencing needs to be delayed a few days. So we would ask that, he remain in jail on a bond, and we come back in approximately a week. Well, I don't care if it was even on this coming Monday, and reassess this situation. Maybe in the meantime, when Mr. Tooley comes back before the court again, he won't be cussing, and he won't be giving people the middle finger, and he'll be reasonable so we can talk about it.
I don't think he did give the middle finger.
Oh, what? Sure, he's doing it right now.
Oh, I take that back.
So I just don't think that we can have a productive conversation about it.
All right. We're going to make this sentencing on 6/5/23 at 10 o'clock, and
You already said a bond, John?
no, I'm going to do that right now. $10,000 cash or surety, and I don't know if this will help you or not, Mr. Tooley, but when you come back here on Monday, you need to help your lawyer. You've got his hands tied, and I think it has to do with, well, I have I'm not going to say what I was going to say. I agree with you, Mr. Heald. He's not helping himself today. And he's not helping his lawyer today. So 6/5/23 at 10 o'clock. And please come back here and help Mr. Morford represent you. Next case.
Thank you, Your Honor.
All right. We're finished with the Lawrence County Jail. Thank you, Mr. Morford, for taking this case.
State of Ohio recalls Keon Gage, case number CRA 23238.
And we already did it.
Okay.
Yep.
Hey, Josh, you might want to get Phil. He might want to have some input on that.
You just went up there.
Oh.
Mr. Morford.
Mr. Heald, Mr. Heald.
Phil. You might want to have some input on this. Your Honor, I've asked that this matter be recalled. I believe it's today that you're in court.
Yes.
For a jail sentence. However, it's come to his attention since he agreed to report today that on Tuesday?
Yes.
Is that your game?
No, Saturday.
Saturday. Excuse me. Tomorrow, he is to coach a semi-pro professional football game. For that reason, he is asking that his report date be delayed 1 week.
Okay, who's the team that you're coaching?
The Port City Spartans.
Portsmouth?
Yes, Portsmouth. Yes, Your Honor.
Who they playing?
We're playing the Mountain State Outlaws. They're from West Virginia. And I didn't realize it when I got the 2 weeks. I didn't realize the date was on there, and it's actually Saturday. That's our first game, and I would like to be there if the judge will let me. I'm not going anywhere. I'm not at flight risk or anything like that. I live maybe 5 minutes right there in Huntington, and I'll be willing to turn myself in afterwards with no problem.
He has in his hands here, Judge, what appears to be airline ticket showing that he did come back this week in time to be here for today's sentencing.
When do you want to report?
1 week, 11 o'clock.
6/9/23 at 11 o'clock. Do you have any objection to that, Mr. Heald?
No, he's come in today, and I think he understands it. We really, I think, were generous in our way we resolved the case before, so I hope he appreciates that, and I hope he does show up. I'm sure he will.
I will.
Your motion's granted, Mr. Morford.
Thank you, Judge. 6/9 at 11.
I'll be there, no problem.
Getting good luck first game.
Yeah.
Right home victory.
Yes, thank you.
Court
Yes, sir.
adjourned.
Music to our ears.
Take down his signature.